to Lawline with your host, Alan Schnorman. Mr. Schnorman is a distinguished trial attorney, author, and lecturer. Each week, Lawline will bring you the most knowledgeable experts in the field of law today. And now we introduce our guest and our host, Alan Schnorman.
Welcome to Lawline. The New York State Trial Lawyers Association has a long-term commitment to protecting the rights of victims of negligence by ensuring the preservation of the tort system. Today we'll meet with its president, Philip Damashek. Philip is a senior partner in the law firm of Damashek, Godowski, and Gentile, and look at some of the important issues the New York State trial lawyers are working on today. Hello, Phil.
Hello, Alan.
Well, Phil, what are your goals as president of the trial lawyers?
To get through this year's president, mainly.
I can understand that. But in particular, what makes your presidency different than the other 6 presidents we've had on our show?
Well, I don't know that the presidency, the Philip Damashek presidency, is going to be that much different. All of my predecessors faced the same problems. Legislation that sought to limit victims' rights, attempts to curtail the nature of the tort system itself. There are a lot of forces out there who believe that people who are injured should just take their injury and go away quietly.
Well, let's talk about who are those forces.
Well, they come in a lot of different shapes, sizes, and names. It can be a large corporation such as Boeing, Procter & Gamble. It could be a not-for-profit organization such as the Boy Scouts of America, or the American Florists Association, or the American Betting Association.
Phil, let me stop you. It's like you're going against Mom's apple pie now when you're talking about the Boy Scouts. Why would they be against the tort system?
Well, they have been convinced, apparently, that some people who would ordinarily volunteer to work for the Boy Scouts will be inhibited from doing so because of fear of being sued because of that activity. Now, it's nonsense. You know it's nonsense. I know it's nonsense. But it's a bill of goods which has been sold to groups like the Boy Scouts, and it's resulted in them joining together, banding together, to try and limit victims' rights.
Now, you're talking about large corporations. Are you talking in reference to products liability or the products they produce?
For each one of these different groups that I've mentioned to you, and there are literally hundreds more, have formed together under an association called the American Tort Reform Association. Their credo and their goal is to do away with the tort system, I'm afraid.
Well, let's discuss it. First of all, what is the tort system?
Okay. In civil law, a tort is a wrong. The law provides redress for that wrong as it currently exists. Way back when we had our first written code of law, when Hammurabi set pen to sand, or whatever it was they wrote on those
That was
days.
before your firm was in...
Well before my firm. The idea was if someone wronged you, they should pay in kind, so that if someone was responsible for another's death, someone in the a survivor from the decedent's family had the right to call for the death of someone in the family of the one who killed that person. Someone got caught stealing, they cut off your hand. An eye for an eye, so to speak. We've come a long way since those days, and basically the law recognizes that there should be a redress for every wrong, and the law seeks to provide redress for every wrong, including civil wrongs. Criminal wrongs, we know if someone does something wrong and transgresses in violation of the criminal law, they pay a price if they're convicted. On the civil side, if you've hurt someone, not intentionally, carelessly, because you fail to exercise that degree of care that we each have a right to expect from each other. And as a result of that carelessness or that wrong, someone has been hurt, it's only fair that they compensate that person for that wrong. But we don't insist on a hand or an eye any longer.
Okay, so now, are you telling us that the large corporations and this group that you just mentioned are trying to take away this ability to be compensated for the wrong?
Absolutely, absolutely. They feel that it impacts on their profits, on their dividends, and they want to see tort law go away. They would like to see, their idea of a healthy economic environment is one that exists without lawyers to represent the people who they might injure because of their own carelessness.
Well, Phil, if you take away something, you have to give something. You just can't take away the ability of somebody to have regress if their son is medically hurt in a medical malpractice case or run over by an automobile.
Well, let's see if that's really true, Alan. The state of Virginia, about 3 years ago, enacted a neurologically impaired infant bill, or what the supporters of the bill, the hospitals and medical institutions, refer to as a bad baby bill. What they were after in Virginia was to take cases, medical malpractice cases, involving those infants who were damaged, injured during birth, profoundly injured, because when a child suffers brain damage at that young age, the injury is generally truly profound, and we're talking about lifelong, serious injuries. The doctors, hospitals, the medical industry, if you will, in Virginia decided that the system should be changed, and they managed to convince Virginia legislators to change the system, and they did. And they provided that they would have a no-fault scheme to compensate neurologically impaired infants in the state of Virginia, and that each doctor would contribute $500 towards this fund. Well, Alan, 3 years later, there has been only one claim with respect to a neurologically impaired infant, and that claim was discharged or dismissed because of technical reasons. No one else but one child made a claim. That child's claim was dismissed. To date, the state of Virginia has not paid 10 cents to any of the neurologically impaired infants who were supposed to be protected under this, quote, no-fault, unquote, scheme.
So you're saying that that basically was a disenfranchisement of a whole group of injured victims?
Unfortunately, yes. It was something that was a bill of goods that was sold to the legislators of the state of Virginia, and hopefully they'll see that that's exactly what it was and re-reform the law.
Phil, I've been reading that medical malpractice claims across the country are down significantly, that premiums for medical doctors are decreasing. Comment on that.
Well, it's true that the volume of malpractice cases in the state of New York, and that's the area that I'm most familiar with, are down tremendously. It is also true that there have been some reductions, and in other cases, freezing in New York State of physicians' insurance rates. There have not been significant decline in insurance rates, but there should be, because there has been a significant decline in the number of medical malpractice cases. That doesn't mean, though, that there's been a significant decline or any decline at all in the amount of malpractice that's committed. We believe quite the contrary, that malpractice goes on and on and on, and in fact the recent Harvard study, which concerned itself with the amount of malpractice in New York State's hospitals, certainly proved that 7,000 people a year, that's the official statistic, almost 7,000 people a year lose their life in hospitals due to medical negligence. Startling, isn't it?
Well, you talked about legislation now. What's the pending legislation now in the state?
Well, the obstetricians and gynecologists are proposing a bill pretty similar to the Virginia bill. They want to have a no-fault system for neurologically impaired infants. The New York State Trial Lawyers Association says absolutely not. And we're going to do everything we can to see that what happened in Virginia. It doesn't happen in New York.
Phil, on one side you have all these doctors and corporations and people who sell products lobbying on one side. Who's on the side of the victims?
The greatest people in the whole world are trial lawyers, my members. The members of the New York State trial lawyers are an incredible bunch of people, men and women who are dedicated to protecting the rights of those people who are injured through negligence, malpractice, bad products, all sorts of terrible things that society should try and get rid of but can't.
Well, speaking about consumers, what's the situation now on raising the limits? I understand that the limits here in the state are $10,000, $20,000, and they've been that way since 1956 or 57.
1957 is correct.
If you took the same $10,000 that was in 1957, I shudder to think what it is today, but I know there was talk about raising the limits. What's the status?
Okay. Well, first of all, Alan, you're right, but it's worse than even you've suggested, in that in between 1957 and today, we enacted a no-fault law in New York relating to automobile accidents that deprives anybody who's hurt in an automobile accident the right to even sue unless they're seriously injured. So look at this. On one hand, we say you can't sue unless you're seriously injured, and on the other hand, we say if you're seriously injured, we can pay you up to $10,000 if you happen to have been hurt by somebody who buys the minimum insurance in New York.
So what's happening, Phil? Are they going to raise the rates?
Well, this year, the legislature, to its credit, has responded to this problem and passed higher mandatory automobile insurance limits, raising limits to $25,000 and $50,000. The bill will have to be dealt with by Governor Cuomo. It does not become law until he signs it. We're working, again, very hard to see that Governor Cuomo makes something right that has been very, very wrong in New York State for a long time.
So you're saying it's in the governor's lap right now?
Yes.
And it's either he'll vote for it, or he'll sign it, or he won't sign it. Is that what the situation is?
The bill, as I understand it, is pending negotiations between the governor's office and the various houses of the legislature, the Assembly and the Senate, but will be resubmitted to the governor, in which case the governor will have 10 days from the time it's resubmitted to him to act on the bill. He will either sign the bill or he will veto the bill.
Phil, I know that sometimes personal injury cases take years. Now, does the person who is injured, do they get interest on these monies until the time they collect it?
No, that's one of the reasons that they can expect to wait as long as they do to get justice. The insurance companies who insure many of the people who have claims against them for injuries feel that it's in their best interest to delay these cases for as long as possible, knowing that there is no penalty. The longer a case takes to be resolved, the longer the insurance company sits with the money and invests the money and enjoys the income and profits from that money, and the longer they keep that money out of the hands of the injured person who's rightfully entitled to it.
So what is being done to correct that wrong?
Well, we're suggesting and we're supporting an Office of Court Administration suggestion on a piece of legislation which would permit prejudgment interest. For instance, in a commercial matter, if I lend you a certain amount of money for a certain period of time and you don't pay me back, I can sue you, and when I do recover a judgment against you, I'll get interest from the time I gave you the money. However, if I am hurt by you and if I sue you, if you can delay me from getting what I'm entitled to, all I'm going to get is the dollar amount that a judge or jury says I get, with no interest from the time you've been stalling me around.
Phil, we're going to continue with this conversation right after this break. You're watching Lawline. Stay with us.
There's a reason people whisper when they tell you a rumor. It's because 9 times out of 10, it's not true. Take all the rumors about AIDS. People are saying you can catch AIDS from a mosquito bite or in swimming pools. The fact is, there isn't a single case of AIDS on record caused by casual contact. It's up to you. You can believe the rumors, or you can get the facts.
Rumors are spreading faster than AIDS. Call your local Red Cross for the facts.
The party's over. All over, one for the road. All over for the 25,000 Americans who die each year as the result of drivers who drink. Drivers who don't realize how little it takes to turn the average social drinker into a tragedy. So please, take this advice from this station and the members of the New York State Bar Association. When in doubt, don't start out.
And now a word from the American Lung Association. Your lungs are an incredible piece of machinery, but your lungs are also incredibly delicate. Diseases of the lung are among the most frequent causes of suffering, disability, and death in the United States. Lung cancer is now the #1 cancer killer in America among both men and women. Chronic bronchitis and emphysema are marked by chronic obstruction to the airflow. Among chronic diseases, asthma is the leading cause of school absenteeism. Yes, TB is still with us. In the past year, over 22,000 Americans have contracted TB. Lung trouble can come from the air you breathe at work, but thanks to the American Lung Association, you can breathe a little easier. They're working to fight all this lung disease. Your lungs are a miracle. Take care of your lungs. They're only human. And if my lungs weren't in great shape, I couldn't have said all this. The American Lung Association. The Christmas seal people.
Hi, I'm Alan Schnorman. You're watching Lawline. Today's topic is the New York State Trial Lawyers Association and their goals. We have with us the president, Phil Damashek. Phil, let me mention a few items and let me ask for your comments on it. Judicial salaries. How do you feel about that?
Well, in the state court in New York State, they really need some revision in an upward direction, Alan. Until recently, New York either was slightly ahead or equal historically to the federal bench. Now the salary for judges in New York State lags pretty far behind the federal bench, and something's got to be done.
Phil, I understand that some first-year associates at the Wall Street law firms make as much, if not more, than some sitting judges.
That's also absolutely true, Alan, and again, it's part of a problem that we have to face and we have to address. For some reason, we neglect the judiciary. We don't think about it. We don't consider their needs. And probably the easy answer is that it's because very rarely do we need the judiciary or the judicial system to work for us individually. But they play a very, very important role in our lives.
Let's continue on that. Court facilities. You walk into some courtrooms, they're no bigger than a closet.
Well, the size is one thing, but there are more and deeper problems with regard to facilities than just the size. We have a situation in which our housing courts, for instance, are in courthouses in which people come to complain about the kinds of facilities that they have to live in. When they get to the courthouse, they might very well feel a lot better about the places that they have to live. Our courthouses are literally becoming slums.
Phil, everybody agrees. Everybody who's been on the show talks about court facilities says, yes, the court facilities are terrible. I wouldn't go into the bathroom in this county or in that county. But year after year, nothing's being done about it.
Well, I can't argue with you in saying that there hasn't been any visible evidence of any improvement, and that's because there really hasn't been any improvement. But there is something called the Court Facilities Act, which Matt Crossan, the current court administrator for OCA, which administers the courts on a statewide basis, Mr. Crossan has been somewhat responsible and very much involved in the Court Facilities Act being passed, which makes the localities
Responsible.
It makes them responsible to provide decent facilities.
Phil, he's going to be on the show next month, and I'll ask him that.
Great.
What effect do you think David Dinkins, Mayor Dinkins, is going to have when he just froze a $2 billion construction program, which included the courthouses?
Okay. What I believe, Alan, that the fact of the matter is the Court Facilities Act permits the state to lean on the localities, force them to do it. If they don't lean on the localities, on the city, on the different towns around the state, nothing is going to happen.
I think in this case you need a little more than leading. I think you need a foot stomping. But let's go on to a different topic. What about reduction of the contingent fee?
People who want to see the tort system disappear have seized on a reduction of the contingency fee as a real cute way of accomplishing their mean ends. If they can do away with the lawyers, then they won't have to worry about dealing with the clients. One of the ways to make sure, let me begin by saying this, Alan, that the most democratic part of our civil justice system is the contingency fee. It permits the very poorest and very richest to hire the same lawyer.
In layman's term, what does that mean, contingency fee?
A contingency fee is where a client retains an attorney without having to pay any upfront fee money, and agrees that they will not have to pay any monies during the course of the claim for which they're retaining the
And in personal
attorney.
injury, normally, Phil, how much is that?
In New York State, it's 1/3 at a maximum, except in malpractice where it's somewhat lower.
What about the change in the New York's Wrongful Death Act?
Okay. New York's Wrongful Death Act is as democratic as the contingency fee is. The New York State's Wrongful Death Act is as undemocratic.
Okay, why?
Because we measure the value of an individual's life solely by how much money they earn.
Well, what if a person's not working? Does that mean they're not worth anything?
Basically, that's it. Under New York law, you're entitled, the survivors are entitled to solely pecuniary loss. So as a result, children and the elderly who are not employed any longer, or in the case of the elderly, have been retired, are worth less than someone who goes to work every day. Women who are housewives and who are bringing up a family because they're not going to business and earning a living, working as their husbands might be, are worth less. Because of this rule, minorities who traditionally and historically earn less are worth less in death as they are in life under New York's wrongful death law.
So in other words, you're saying that an investment banker family who's making, let's assume, $100,000 a year would get, what, 10 times more than the porter in the building family, yet they both have 3 children to support, and they both have a wife?
Well, you use the multiple of 10. It could be 20 or 30. Absolutely. That's the way the law works. We only, in New York State currently, permit a jury to award damages for pecuniary loss, money lost.
What about caps on recoveries?
Caps on recoveries are limitations, artificial limitations, on what a jury believes should happen. Those forces, again, who want to weaken and destroy the tort system argue for caps on pain and suffering. It's a terrible anathema to anybody who believes in this country that that the jury system should be limited to having an industry-enforced artificial cap become legislation.
What about the value of the jury system?
They're the greatest. They're not perfect, but jurors are the greatest. And sometimes people don't understand that jurors are them, the public. They're the jurors. We cause them to leave their businesses, their families for a while and come down and serve in a system that's really great. It's better than anything, any place else. They're the ones who, in the end, tell us who's right, who's wrong, who's guilty, who's innocent. They're the ones that we can trust because they don't care. They're not professionals. They're coming down to do a civic function, and they're wonderful, and God help anybody who tries to do away with them.
Phil, if I give you a crystal ball and I set it right over here and it's a big ball and you looked inside of it, where would the tort system be in 10 years?
Alan, as technology develops, so do the things that can go wrong with that technology. We don't like to think about some of the terrible things that can happen when things go awry. But I think the atomic age has proven to us that with all these miracles of science come some terrible possibilities when things go wrong. God help us if we ever have something like Bhopal in this country. God help us if there's a nuclear disaster in this country. God help us if the toxic polluters aren't stopped. But until that happens, all that stands between having them have their way with the ecology, with the environment, are the trial lawyers who represent victims of their wrongdoing.
Philly, in the couple of moments we have left, what would you like to tell the public? This is your opportunity. About the tort system, about your presidency. Go ahead.
Well, I'd like everybody to understand that lawyers are committed people who have spent time in getting a legal education, who believe in a legal system that lets us solve our problems in a court of law as civilized human beings. We don't take our disputes to the streets with guns and bats. If we have a dispute, we permit it to be resolved in a court of law, having a jury decide who is right and who is wrong. We have all the safeguards by way of appellate review, but the system that we have involving lawyers who advocate on behalf of litigants is a good one, and one which merits support by the general public at large. And I hope that they will understand that most lawyers are dedicated men and women who believe in the justice system of this country.
And if you wanted help in support of any of the bills that you have now pending or are trying to not to be passed in Albany, which ones would you single out for support?
Well, I think some of the ones we spoke about earlier, Alan, are really important. The wrongful death law should be changed, and it should
to make
be
it equal.
reformed. To make it equal. People have a right to expect that their life is worth something, whether they're an executive or a laborer.
And with that, thank you very much, Phil. Time has come to an end. Thank you for appearing on Law Line. And as always, this is Alan Schnorman, and thank you for watching Law Line.
You have been watching Law Line with your host, New York trial attorney, author and lecturer, Alan Schnorman. Mr. Schnorman will be back with you next week at the same time. If you have any questions or comments about this week's program, please write to Law Line, 27th floor, 63 Wall Street, New York, New York, 10005.